The Standing Committee on Citizenship and Immigration, CIMM, held its third meeting on September 24, 2025, focusing on fraud in Canada's international student program and the government's responses. We have Mirza Asma Azim, legal counsel and immigration law expert, with us today to ask a few questions. Mirza, how extensive is the problem of fraudulent letters of acceptance and LOAs affecting international student admissions, and what has been the response from Canadian authorities?
Well, the issue is systemic. Fraudulent LOAs have exploited hundreds of vulnerable applicants, often through unscrupulous and ghost consultants, and the courts, such as the federal court, emphasize the duty of fairness owed to student applicants facing misrepresentation allegations. Recognizing the scale, IRCC and CBSA launched the Task Force for Genuine Students, intercepted approximately 14,000 fraudulent LOAs, and conducted sweeping investigations. The government responded by increasing oversight and instituting mandatory LOA verification for all study permits, aligning with the principles of administrative fairness and the necessity for transparent, well-reasoned measures to protect genuine applicants.
Has the government implemented new policy reforms specifically since January 2024 to address fraud, and what are their legal implications?
Absolutely, Samuel. In line with the federal court's recent decision in Kaur versus Canada, which stressed the need for targeted action against systemic abuse, IRCC introduced an intake cap, doubled the minimum financial requirements to $22,895, and enhanced language eligibility standards for both study and postgraduate work permits. These reforms reflect a reasonableness approach as clarified by the Supreme Court in Vavilov versus Canada. The requirement for biannual student compliance checks, coupled with robust data sharing measures under Bill C-2, demonstrates the government's intent to balance effective regulatory enforcement with the rights and interests of affected individuals. Any action perceived as overbroad or arbitrary may be subject to judicial review under the Charter's Section 7 protections.
What recent data exists on the number of non-compliant or fraudulent study permit holders, and how does this tie into removals and asylum claims?
IRCC has flagged around 8% of reporting students, nearly 47,000, as potentially non-compliant. However, removal orders and enforcement fall under the CBSA's mandate. Overall, there were 18,000 removals in 2024, but the number of removals specific to students remains unclear.
How does Bill C-2 aim to strengthen system integrity, and are there charter concerns related to privacy and procedural fairness?
Bill C-2 seeks to unlock greater data sharing between IRCC, CBSA, and provincial partners, allowing for mass cancellation of immigration documents in public interest cases, such as broad cyber fraud. From a legal perspective, Section 8 of the Charter may be engaged where personal data is widely shared, and the Supreme Court in Crown v. Spencer 2014 affirmed safeguards for individual privacy. Procedural fairness is further protected under Baker and Vavilov, requiring advance notice and proportionality in enforcement actions. The Refugee Law Lab raises questions about Charter compliance regarding certain provisions, particularly those related to mass document cancellation and asylum access, which may ultimately require judicial scrutiny to determine constitutional consistency.
What impact have these measures had on the distribution of students between premium research universities and shopping mall diploma mills?
Data suggests a measurable change, Samuel. Following the reform, the percentage of university degree students increased from 30% to 33%, while the share of college students declined from 44% to 40%. These trends mirror the Supreme Court's endorsement in Trinity Western University versus Law Society of Upper Canada of tailored administrative discretion, where compelling public interest, sector reputation, and institutional integrity should guide government allocation choices. The government's pivot toward rewarding premium institutions underscores an effort to safeguard academic standards, mitigate exploitation, and uphold Canada's global reputation for education. The standard of our public institutions, whether a public college or a public university, upholds the same academic standards.
Mirza, from a legal risk perspective, what do these trends and reforms imply for designated learning institutions, students, and future program oversight?
The legal trajectory is clear. Institutions must comply with governance reforms or risk losing their DLI status, an outcome supported by B010 versus Canada 2015, which validates the government's right to demand compliance as a prerequisite for program participation. For student, procedural fairness and access to judicial review remain vital, especially where allegations of fraud or misconduct arise. For future oversight, the increased focus on proactive fraud detection, interagency data sharing, and compliance audits represents an evolving legal landscape where both public safety and individual rights must be scrupulously balanced.
Are similar cases of international student visa fraud and exploitation being witnessed in countries like the United States, United Kingdom, and Australia? If so, what significant enforcement or legislative measures have been implemented there recently, Mirza?
Indeed, Samuel, comparable challenges and substantial policy responses are evident across major study destinations, and legal scholarship has noted convergences in both best practices and risks. Cases like the pay-to-stay Farmington University sting operation have prompted robust federal reforms. The 2025 Student Visa Integrity Act enforces the immediate withdrawal of SEVP, Student and Exchange Visitor Program certification from schools suspected of fraud without waiting for lengthy investigations, mirroring the Canadian decertification approach for DLIs. U.S. consular officers are now required to refer certain visa applicants to the Fraud Prevention Unit for social media and background checks. The Department of Homeland Security has also expanded its capacity to decertify institutions and bar them from issuing I-20s. The UK government has, since 2024, targeted both rogue recruitment agents and non-genuine students. As of 2025, all institutions must participate in strict compliance frameworks for agents, and sponsor license penalties now apply to institutions that allow students to enter the country but then fail to enroll, pass visa checks, or attend classes. Financial requirements were raised, and changes to the graduate route visa shorten the post-study work period, placing more pressure on genuine academic progression. Regulatory reviews stress English language proficiency and restrict remote delivery to reduce abuse, aligning with concerns flagged by the Migration Advisory Committee. Australia's July 2025 reforms are particularly far-reaching. Confirmation of enrollment is now mandatory before a student visa application, replacing the previous letters of offer. Living cost thresholds and application fees have been increased, and onshore visa extensions are banned to prevent visa hopping abuse. A new cap on university intake further restricts non-genuine flows, while English language requirements and genuine temporary entrance standards are meticulously enforced. The institutions and students face rigorous compliance scrutiny, with strong parallels to the Canadian experience. Thus, like Canada, these countries are instituting sharper gatekeeping, increased compliance checks, and serious penalties for institutions and intermediaries implicated in fraud.
Thank you so much for giving us your time, Mirza. We also thank our viewers for watching this session and engaging with these important issues in immigration policy and law. If you found these insights useful, please subscribe to our channel and stay tuned for more informative discussions, case law analysis, and policy updates in the future. We appreciate your ongoing support and look forward to sharing further valuable content with you. Thank you for watching and joining this vital conversation on global immigration integrity.